law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey, welcome everybody. Welcome. Hopefully we're live now. Sorry, got caught there by surprise a little bit by my own audio. Welcome to the Law of Self-Defense show for September 30th, 2021, where today we'll be talking about what to expect from the Ahmaud Arbery trial and the Kyle Rittenhouse trial, scheduled to be starting in just a couple of weeks for the Arbery case and in about a month for the Rittenhouse case. For those who don't know, I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you very much. As always, that's greatly appreciated. So come on in. I will try to answer questions before the end of the show. If you're watching this live, it's airing live currently on Facebook and the Law of Self-Defense membership page. And before the end of the show, we usually try to stop by the top of the hour. I'll scroll through the comments to see if there's any questions I can address. So feel free to put your questions in the comments as you begin. If you're watching a playback of this, as we do on YouTube, I may or may not be able to answer questions you post there. It all depends on my time availability. So we do the show every week, by the way, every Thursday, just about every Thursday at 4 p.m. Eastern Time, 2 p.m. Mountain Time, where I am outside of Denver, Colorado. So you might want to mark your calendars. Do whatever you do on Facebook to get reminded of these things. And of course, we do post a replay on YouTube as well. So if you're watching on YouTube and you'd care to hit that subscribe button, click the bell indication so you're made aware of when our weekly shows take place, that would be greatly appreciated to help expose others about the show as well. And before we jump into the substance of today's show, I do, of course, have to thank our sponsor of this content and some future content we'll be sharing in a moment. That sponsor is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, they promise to pay their members legal expenses if the members charged in a use of force event, and those expenses start big and get bigger fast, folks. Imagine a scenario where you've been threatened, you display a gun, you tell the aggressor to stay back, that ends the fight, and then you find yourself charged with aggravated assault with a firearm, which is the most common case I consult on under those kinds of circumstances. You're usually looking at a retainer to your lead counsel of $30,000 to $50,000 for pre-trial expenses, folks. That doesn't even cover the trial. If you've killed someone in self-defense and find yourself charged with murder or manslaughter, it's very easy to burn through $200,000 pre-trial before you ever get to trial. So if you don't have the kind of money stuffed in a mattress, in case you're compelled to defend yourself or your family, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought. And that's what CCW Safe does for its members. Now, I've reviewed all these various quote-unquote self-defense insurance programs out there. In my opinion, CCW Safe is by far the most advantageous to be a member of. I'm personally a member of CCW Safe. My wife, Emily, is a member of CCW Safe. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer after today's show by pointing your browser to lawofselfdefense.com/CCWSafe. And if you do decide to become a member there, you can save 10% off your CCW Safe membership by using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCWSafe. Okay, let's dive now into the substance of today's show, and that is what to expect from the Ahmaud Arbery and Kyle Rittenhouse cases. By the way, folks, any of you happen to follow Russian news media, I'm scheduled to be interviewed by Moscow-based NTV News tomorrow morning, 5:30 a.m. Mountain Time, 7:30 a.m. Eastern Time, so perhaps not too early for some of you on the East Coast if you have access to Moscow-based news. Frankly, NTV News appears to me to be largely a Russian propaganda news outlet, but that doesn't bother me. That's really no different than being interviewed by the typical U.S. news media. So it should be fun. They're interested in these U.S. concepts of self-defense versus murder, and of course, cases like the Ahmaud Arbery trials about to take place and the Kyle Rittenhouse case. And if you missed that, I'll also be on Coffee with Rich tomorrow morning. That's a show hosted by Rich Brown of American Warrior Society. That'll air live on Facebook at 6:30 a.m. tomorrow morning, Friday, October 1st. And you can access that at facebook.com/American Warrior Society. That should be a good time as well. Now, these two cases that are coming up, I'm calling the first the Ahmaud Arbery case. Of course, Ahmaud Arbery is not on trial. Ahmaud Arbery was killed in this event. The defendants in the case are Greg McDaniel, Travis McDaniel, and Roddy Bryan. So we'll talk about that case in detail in just a moment. The second case, of course, is the Kyle Rittenhouse case, which we did some coverage of recently because of the pretrial evidentiary hearing they just had. But before we step into each of those cases, I'd like to frame how this discussion of the cases should be perceived. Where most people struggle in doing a proper legal analysis of these kinds of cases isn't something like a lack of generalized intelligence. Most people get these cases wrong, their analysis wrong, not because they're not smart enough to figure it out. It's because of their inability to strip the purely emotional facets out of the case and strip out the evidence-free claims about the case, strip the emotion and the evidence-free claims out of their analysis. Now, it's normal for human beings to become emotionally invested in whatever narrative of events they believe is true. And once they've done that, once they've become emotionally invested in something they believe is true, note that's different than whether or not it's actually true, which nobody really knows anyway, or more relevant for our purposes, whether what they believe is actually supported by actual evidence. Completely different thing than simply believing something is true. If they've become emotionally invested in that belief, it's almost impossible later for them to acknowledge that perhaps their belief was mistaken. And these misperceptions of these cases is enormously complicated by prosecutors who willingly mislead the public on the evidence, bring charges that, in fact, don't have any basis in evidence. We have legal procedures that are supposed to prevent that. Things like before you can be dragged into court on a charge, the prosecution's supposed to show probable cause exists for the criminal charge brought against you. But as a practical matter, the probable cause threshold is so low that if a prosecutor wants to bring you to trial, it's almost impossible to prevent them from doing that. We've all heard the expression, a grand jury will indict a ham sandwich. Well, that's because the grand jury really only hears the prosecution's narrative of what happened in the events. And if you only hear one side of the story, it shouldn't be surprising to anybody that that side, the only side you heard, sounds pretty compelling. That's why our legal system is designed to be adversarial in process, meaning you have two competing sides. In the criminal case, the prosecution and the defense, to try to ensure that the actual jury is hearing both sides of the story. And how powerful this emotional commitment to a belief, even if it's evidence-free or based purely on propaganda or purely on what people want to believe is true, with arguably often with the best of intentions, was really brought home to me on occasions where I've taught at the FBI Academy in Quantico for their National Academy program. And I'm presenting there on these highly controversial cases, like the George Zimmerman case, for example, and others. And I'm observing this behavior, this power of propaganda, misinformation to convince people of a false narrative of what happened. You can then show those people absolute, incontrovertible evidence that their understanding of the events is mistaken, that they were lied to, that they were misled. And yet, even in the face of that incontrovertible evidence, they find it impossible to break themselves from the false narrative to which they've emotionally committed themselves. And that's not because they're bad people. Certainly, it's not because they're stupid people. We're talking about senior level FBI, law enforcement, career officers, very, very good at their jobs, or they wouldn't be at the levels they've achieved. It's just because they're normal human beings, and normal human beings become emotionally invested in what they believe is true. I mention all this because we have to be on guard against that ourselves. If we're going to engage in proper, substantive legal analysis rather than merely emotional speculation about these cases. So just a cautionary note there before we dive in. I also want to point out that in both these cases, the Ahmaud Arbery case and the Kyle Rittenhouse case, it's entirely appropriate to argue that all these people, the McMichaels, William Roddy Bryan in the case of the Arbery matter, Kyle Rittenhouse in Kenosha, that all of these people engaged in poor judgment. They put themselves in a position where physical and legal peril was highly likely, and they're now suffering the consequences of having put themselves in that position. So anybody can say that the McMichaels should never have chased Arbery in what they claim is an effort to make a citizen's arrest, that Kyle Rittenhouse should not have gone to Kenosha with that AR to protect that car lot or to offer whatever expertise he had in medical treatment for people who might have been injured. Because doing so creates a lot of risk, physical risk and legal risk. And obviously, all those parties are not paying the price for that. And that's true. We can say, don't go to those places. If Kyle Rittenhouse was my son, I would have told him not to go there. If the McMichaels and Roddy Bryan were clients of mine, I would have told them not to engage in armed citizens' arrest. But poor judgment by itself is not a crime, folks. Crimes have very specifically defined elements, each and every one of which must be proven by the prosecution beyond a reasonable doubt. The fact that someone might have engaged in conduct as a result of poor judgment does not by itself, make that conduct criminal. So the fact that they used poor judgment and got themselves in these situations in the first place, that's not a basis on which to convict somebody of a crime. And by the way, one of the most common things I see in gun forums and self-defense threads on social media and so forth are these incidents where some poor innocent person is the victim of criminal predation. They're getting beat down, they're getting robbed, whatever the case might be. And all the bystanders just kind of, maybe they take video with their cameras, maybe they walk away, they don't want to be involved. And in these forums and social media threads, people are outraged. Why didn't somebody do something? Why didn't somebody intervene? How could they just stand around and let this happen to that poor innocent victim? And there's nothing illegitimate about that point of view. Nothing illegitimate. But maybe the reason those people just stand around and don't intervene is because of these kinds of cases. Because of George Zimmerman, who was merely a neighborhood watch volunteer trying to do the right thing for his community. Because of the McMichaels and Bryan, who, from their perspective, their narrative of the events, were making use of Georgia's existing and well-established citizens arrest law to pursue Ahmaud Arbery, who, from their perspective, was apparently in flight from a felony burglary. People like Kyle Rittenhouse, who put himself in a position of peril, he would say, not out of malice, but to protect property in Kenosha and to provide aid to people who might be injured in the course of the crazy riots and property destruction that was occurring there. If you ask any of them, they'll tell you, hey, we were just trying to do the right thing. When suddenly we found ourselves compelled to engage in lethal force self-defense against a life-threatening attack. So with all that in mind, I would also urge you to keep in mind that you adopt an attitude of any claims, of any of these cases, and that includes any claims made by me, folks, of show me the evidence. If someone makes a claim, see the evidence. Demand to see the evidence, because you'll discover that a lot of the claims in these kinds of cases are evidence-free. They're just a lie that someone fabricated that now has been told 1,000 times, and because people saw it 1,000 times in the newspapers or on social media, they just assume that it's true. It's often not true. Look for the underlying evidence. And if you can't find it, that's a pretty good indication that what you're looking at is a lie, not a reasonable inference drawn from available evidence. And don't engage in mere speculation or mind reading. You don't know what's actually going on in someone's mind unless there's evidence from which you can make a reasonable inference. So, bottom line, be careful of evidence-free claims, and that's mostly what's propagated by the media, by, of course, propagandists, and by politically motivated prosecutors. So with all that set forth, let's take a look first at this Ahmaud Arbery case. So the actors in this case are, of course, Ahmaud Arbery, who was killed in these events. The defendants in this case are Greg McMichael, father, Travis McMichael, his son, and neighbor William Roddy Bryan. It was Bryan who was following behind in his own vehicle, making the infamous videotape of the final encounter between Arbery and the McMichaels. And of course, all these men have been charged essentially with identical charges. Now, what's in all of these trials, in any criminal trial, what we're always dealing with, folks, is two competing narratives, two competing stories that are being presented to the jury. And of course, the prosecution is seeking to present a narrative of guilt, and the defense is seeking to present a narrative of innocence, or at least a reasonable doubt of guilt, right? Because the state's narrative of guilt, in theory, needs to be proven beyond a reasonable doubt. So if the defense can raise a reasonable doubt, the jury's instructed that they are to acquit on any criminal charge for which any element is one about which the jury has a reasonable doubt. So we have these two competing narratives. So for each of these cases, the Arbery case and the Rittenhouse case, I'd like to just set forth the narratives that are being put forth by each of the sides. So in the Arbery case, the state narrative is effectively that Ahmaud Arbery was recreationally jogging through a suburban neighborhood, was observed by Greg and Travis McMichael, who decided to arm themselves and jump into a pickup truck with the malicious intent to drive Arbery down in the street and shoot him to death. And that Roddy Bryan, the third defendant here, worked cooperatively with the McMichaels in these crimes, so all three men are facing similar charges. Now, the most serious charge here in this case, of course, is the first charge of malice murder, which will be good for almost certainly life in prison. Sorry, I forgot to update my notes on this. But you can look at the criminal indictment, and this part of the narrative by the state is that these defendants did unlawfully, with malice aforethought, cause the death of Ahmaud Arbery, a human being, by unlawfully chasing him through the public roadways of this neighborhood in pickup trucks and shooting him with a shotgun. Now, of course, the legal defense of this on the part of the defendants is going to be self-defense. We'll come to their part of the narrative in a moment. Then we have, after the malice murder charge, we have a number 4 of felony murder charges. So felony murder, of course, is a murder that was not intentional, but that resulted as a direct consequence of some underlying felony conduct. So I'm not going to go into these on details because each of these 4 charges of felony murder is premised on an underlying felony. And if that underlying felony is proven, well, then it's the felony murder is proven. Clearly, the death occurred as a consequence. So we'll look instead at the underlying felonies that are the premise for the predicates for these felony murder charges. So the first of the underlying felonies is aggravated assault, that the McMichaels threatened Arbery with deadly force readily capable of causing death or serious bodily injury. There's 2 counts of felony aggravated assault. One of them involves, naturally, the firearms they were possessing, the shotgun possessed by Travis McMichael, and I believe it was a .357 Magnum pistol possessed by his father, Greg McMichael. The second aggravated assault charge is actually based upon their deadly force use of their pickup truck, that they were using the pickup truck with the intent of creating in Arbery's mind a reasonable perception of an imminent deadly force threat, presumably that they would run him over with the pickup truck. So 2 counts of aggravated assault, 1 for the firearm, 1 for the pickup truck, both of those then the predicate for charges of felony murder. We also have a charge of false imprisonment. Now, false imprisonment is really any time you constrain someone's freedom of movement. The legal defense to false imprisonment would be citizen's arrest. In other words, it was not false imprisonment or unlawful imprisonment. It was lawful imprisonment or arrest, lawful detention under Georgia's citizen's arrest law. Now, I've read Georgia citizen's arrest law, and it's got plenty of room for criticism. It dates back to 1865. It had never been substantially updated. It was a very broad privilege of citizens to make an arrest of another citizen. But nevertheless, it was the law in place at the time of these events. It's since been repealed, but it was the law in place at the time of these events. And frankly, from my reading of the law as applied to the facts of this case, it looks to me like there's a good basis for a claim of legitimate citizen's arrest in this case. More importantly, people in Georgia should now be aware that because the citizen's arrest law wasn't just modernized, for example, or constrained, it was repealed. There is effectively in Georgia now no privilege of citizen's arrest at all. And if you detain someone without a privilege of citizen's arrest, you have committed false imprisonment under Georgia law, and that's a felony. By the way, folks, if someone breaks into your home and you take them at gunpoint, don't shoot them, but intend to hold them for the police to arrive, guess what you've just done? Well, that would normally have just been a citizen's arrest. Now it's felony false imprisonment. So I would strongly discourage you from detaining anybody under any circumstances, because under Georgia law, you currently don't have a privilege of citizen's arrest. Now, there is some very limited provision allowance for merchants and shoplifters, for example, but these are very narrowly defined exceptions. There is no generalized citizen's arrest privilege under Georgia law anymore. So I would caution you not to inadvertently, with the best of intentions, end up committing felony false imprisonment and looking at several years in prison. So that's the eighth charge. And again, that's a felony, false imprisonment. So that's another predicate for the third felony murder charge against these men. And finally, we get to count 9, which is criminal attempt to commit a felony, criminal attempt to commit the false imprisonment. You think this would be duplicative? I imagine if they were to find themselves convicted of both, one of them would be dismissed, at least for sentencing purposes. But this is another felony charge. Criminal attempt to commit a felony is itself a felony. So the idea here is, even if the jury concludes that, well, they weren't actually committing false imprisonment, they were just attempting to, you'd catch them on this felony, the criminal attempt felony, and therefore you'd catch them under one of the felony murder provisions as well. So those are all the charges against these three men. That's the state's narrative. Again, that they simply decided with malice to unlawfully chase Arbery through the neighborhood and attempt to and threatened him with deadly force harm through the use of their pickup trucks and the shotgun. So what's the defense narrative here? Well, the defense narrative is that, in fact, the McMichaels either observed or on good information believed that Arbery was in flight from a felony burglary. And by the way, there's no question that Arbery was in the dwelling in question without license. He entered the dwelling unlawfully. He's captured on camera inside the dwelling. And entering a dwelling unlawfully for the purpose of committing a crime, like a theft of property, is felony burglary under Georgia law. And it's not required that something actually be taken. All that's required is that you entered the property for the purpose of committing a crime. If you get into the property and you see there's nothing worth taking, and that might have been the case here because the property was under construction, which still counts, by the way, folks, for Georgia felony burglary statutes, very broadly defined burglary statute. If all you did was enter for the purpose of stealing something, if the opportunity presented itself and it didn't, well, you've still committed felony burglary, even if when you flee, you didn't have any stolen property in your possession. And for purposes of Georgia citizens arrest law, it's not necessary for the arrest to be lawful, a lawful citizen's arrest, that you actually committed the suspected underlying crime. It's only required that you had a reasonable belief that the underlying crime had been committed, that you had probable cause to believe that the underlying crime had been committed. And seeing someone, this is your neighbor's home, you know who's allowed to be there. You see someone who you believe is not allowed to be there, they enter, then they flee. Well, that checks all the boxes for lawful citizen's arrest under Georgia's then existing citizen's arrest law. And if you're allowed to actually arrest someone, which is what the citizen's arrest law obviously allows for, well, then pursuit and detention are inherent parts of making an arrest, right? In order to make the arrest, you have to have the person in your possession. So if they're in flight, and the citizen's arrest law of Georgia, in effect at the time, specifically had a provision for a person in flight from a reasonably perceived felony, well, to make the arrest of a person in flight, you have to pursue them, and then you have to detain them. So the pursuit and the detention themselves can't be unlawful conduct if the citizen's arrest would have been lawful under the law in effect at the time. And of course, the defense position is that that's exactly what was taking place. In terms of the McMichaels being armed, well, Georgia allows for open carry of firearms. So that itself is not unlawful. Now, where, of course, the waters get treacherous for them is if it could be shown that now, when you watch the video, what you'll actually see when you watch the video is the McMichaels pickup truck is stopped. Travis McMichael is standing outside the driver's side door holding a shotgun. The father is in the bed of the pickup truck holding his pistol. And they don't move to Ahmaud Arbery. Ahmaud Arbery charges Travis McMichael and fights Travis McMichael for his shotgun. Now, if that was in response to the McMichaels first threatening Arbery with their guns, well, then you could argue that Arbery was acting in self-defense against the initial aggression of the McMichaels. But that aggression can't simply be the pursuit or the detention, because those would be lawful under citizen's arrest, nor can it be simply the possession of arms, because that's lawful under Georgia's open carry law. It would have to be an actual threatening motion with the firearms. I've looked at the video and I don't see that, but that will necessarily be the position argued by the prosecution. And of course, the defense is going to argue that, hey, we were armed in self-defense, which is perfectly lawful, and we did not threaten Arbery in any way until he charged and attacked Travis McMichael for possession of Travis's shotgun. So those are really all facts of the case. Of course, the intent of the McMichaels might be subject to dispute, but the facts of the case are consistent with this defense narrative, and that's what the prosecution is going to have to overcome. Again, I caution against mind reading. As I said at the beginning, you can't assume that you know that in absence of evidence that the McMichaels had some malicious purpose behind their pursuit of Arbery, absent evidence of that malicious purpose. So what did they engage in that was clearly outside the bounds of the law? Remember, their guilt has to be proven beyond a reasonable doubt. So what conduct did they engage in when they initiated that pursuit to indicate it was being done with unlawful malice? That's the burden the prosecution is going to have to overcome in this case. But that's what we should expect. Those are the two narratives that will be argued out in the trial of the McMichaels and defendant Brian on those various charges. So let's take a look now at the Kyle Rittenhouse case. So we have some real recent insight into the narratives here, because we just had this lengthy pretrial evidentiary hearing in the case. We covered the first half of that in last week's show. I indicated then that I would cover the second half in a part 2, but frankly, time didn't permit that in terms of YouTube content. We did provide a very detailed and well-structured analysis of the entirety of the hearing for our Law of Self-Defense members. And by the way, for our members, you'll be able to find all our coverage of both these cases with respect to the Arbery case by pointing your browser to lawofselfdefense.com/Arbery, and with respect to the Rittenhouse case by pointing your browser to lawofselfdefense.com/Rittenhouse. We're going to have all our coverage aggregated on each of those pages for those trials. So we had this very detailed, extensive, almost 3-hour long evidentiary hearing, a lot of talking by the parties involved. So in doing that, they provided pretty good insight into what they expect their narratives to be. And here I'll focus on the state's narrative on statements made by Assistant DA Binger, who is the lead prosecutor on this case. And I'm stringing together a bunch of sentences drawn from my transcript of that hearing. So this was not said in one long statement, as I'll share it here with you. This is sentences picked out here and there from the transcript. But I'm going to stitch them all together to give you a kind of a comprehensive view of what the state's argument is here. Before I do that, let me step through the criminal charges here. Let's see, that are brought against Rittenhouse. The first is first-degree reckless homicide. So reckless homicide, an unintentional killing, but one that is criminally reckless. Recklessness occurs when you create a unjustifiable risk of serious harm to others, and then you consciously ignore the risk that you've taken, engage in the conduct anyway. The classic example would be intentional drunk driving, for example. Then you run someone over. By engaging in drunk driving, you created an unjustifiable risk of death to the general public, and then when you run someone over and kill them, the actual harm results. So you never intended to run that person over and kill them. It's not an intentional homicide, but it's a criminally reckless homicide. And this is for the shooting of Joseph Rosenbaum. That was the first man to attack Kyle Rittenhouse in the used car parking lot. And if convicted on this charge, Rittenhouse is looking at 60 years in prison with a gun enhancement on the sentence of an additional 5 years. So 60 years plus 5. The second criminal charge is another recklessness charge. So not an intentional act. And that is for the reckless endangerment of a journalist who is on the scene, Richard McGinnis. This could occur if, for example, you swept your muzzle over a bystander. That's essentially what the state is arguing here, that Kyle didn't harm McGinnis, didn't intend to harm McGinnis, but his conduct was such that it recklessly endangered McGinnis. And if convicted on this, Kyle's looking at 12 years in prison, plus, again, 5 years for the gun enhancement. The third charge here is first-degree intentional homicide. So this is the first and only intentional homicide charge in the case. This is for the shooting of Anthony Huber. Anthony Huber was the man who attempted to strike Kyle in the head with a skateboard as Kyle was fleeing for police, and was shot by Kyle and killed. If convicted of this sentence, Kyle's looking at life in prison, and believe it or not, they still do this, life plus 5 years for the gun enhancement. The fourth charge here is attempted first-degree intentional homicide. This was for the shooting of Gage Grosskreutz. This was the man who was shot in the bicep, the third man shot by Kyle that evening. Of course, Grosskreutz was approaching Rittenhouse with a Glock pistol in hand. But nevertheless, the state's arguing that Rittenhouse intentionally attempted to unlawfully kill Grosskreutz, and if convicted on this charge, Kyle's looking at 60 years, and again, plus 5 years for the gun enhancement. Then we have a really somewhat odd charge, first-degree reckless endangerment with an unspecified victim, just some unknown male. That's literally what the indictment says. Apparently on video, they can vaguely make out some unknown male who's never been identified, they believe was recklessly endangered in the same manner that Richard McGinnis was endangered. And therefore, we have this charge of reckless endangerment of an unknown male. If convicted on this, again, 12 years plus 5 years for the gun charge. And finally, we have, after all those felony charges, and all of those are felonies, we have a misdemeanor charge of possession of a dangerous weapon by a person under 18 years of age. And frankly, Wisconsin law on this issue is rather convoluted. So you have to step through various different gun possession statutes with various different exceptions and references to other statutes. I have done that analysis, and in my professional opinion, there is no unlawful weapons possession violation here on the facts of the case. And in fact, this charge is still specifically being argued by the defense and the prosecution. The defense arguing that there's literally no probable cause on the facts of the case that this offense occurred. The prosecution, of course, still has to submit a motion to the court defending this gun possession charge. Again, the threshold for them to get the charge into court is very low, so they may well accomplish that. In any case, this gun possession charge, which once more, and based on my analysis, is completely invalid and has no basis in fact or law here. But it's a misdemeanor, Class A misdemeanor, good for 9 months in jail and up to a $10,000 fine. So listen, if convicted of that, it's hardly a big deal considering the life and 60-year sentences and 12-year sentences awaiting conviction on any of the other felony charges. And it's worth noting, of course, that with the reckless homicide, the intentional homicide, the attempted homicide, these are all the big felony charges, the 60-year and life sentence charges. All three of those were uses of force committed against people who were captured on video in the process of attacking Rittenhouse. All of them. Rosenbaum, Huber, Grosskreutz, all of them were actively engaged in attacks on Rittenhouse. So I think it's going to be quite a challenge for the prosecution to get convictions on those if, of course, they have anything like a reasonable jury, which is a subject for another day. And I think this is why the prosecution's narrative of the case is really so ambiguous and doesn't really target any of the specific elements of any of these criminal charges. Intentional homicide, that the homicide was intentional, which is effectively the case here. I mean, Kyle doesn't deny that he intentionally fired at these men. He's arguing self-defense, which is, of course, a defense of often referred to as confession and avoidance. You're not denying that you committed the underlying act. You're conceding that you committed the underlying act. It's not, it wasn't me, someone else did it. It was me. I did it. I shot these men. But I did so under circumstances that qualify as lawful self-defense. And the prosecution is not really targeting any of this. So let me share with you the little quotes I pulled from this recent pretrial evidentiary hearing by Assistant DA Binger, the lead prosecutor in this case. Quote, the theory of the state's case here, which is that the defendant is essentially a teenage vigilante involving himself in things that don't concern him. The defendant throwing himself into situations that don't concern him, that he has no complete knowledge of, that no one asked him to be involved in, and using force or threatening to use force in an unjustified, illegal, unwarranted manner. The defendant is taking it upon himself, taking the law in his own hands, under circumstances where he doesn't know the full facts, he's making assumptions, and he appointed himself a vigilante, taking the law into his own hands in those circumstances. And that's the end of the quote there from ADA Binger. And among the circumstances that Binger is characterizing as Rittenhouse taking the law into his own hands is things like Rittenhouse carrying a fire extinguisher to put out a fire. That's taking the law into his own hands, or observing an apparent robbery of a CVS pharmacy and calling 911 to have the police come to the scene. Not intervening in any way, not taking action to intervene, not honking the horn of his car, not verbally intervening in no way whatever, except calling 911. The prosecution's attempting to characterize that as Rittenhouse taking the law into his own hands. Or the incident where Rittenhouse's sister was in a fist fight with another woman and Rittenhouse intervened in that fight to, he would say, I presume, to defend his sister. That's supposed to be taking the law into his own hands, even though Wisconsin, like every other state, has a well-established defense of others justification for doing exactly that. So the fact that the prosecution is attempting to characterize these things, and I believe most of us would agree that calling 911 is when you have a reasonable belief that you're observing a crime in progress, is an unvarnished good. We want people to do that. We want people to call the police. If you see something, say something, right? If we're going to characterize calling 911 as taking the law into your own hands, well, as I noted earlier, a lot of people who bemoan the fact that bystanders are not intervening in these events. What now? Bystanders are supposed to believe that even if they merely call 911, that will be characterized as vigilante conduct, them taking the law into their own hands? I mean, it's really a reprehensible argument by the prosecution. It can only cause social harm to discourage people from doing these things, coming to the defense of others, putting out fires, calling 911 when you see an apparent robbery in progress. But apparently that's all the prosecution has, which does not bode well for the prosecution. One other thing I wanted to mention too, and I don't remember if I mentioned it last week, but it's really, I find it interesting, not from so much a legal perspective, but from a gun perspective. As most of you know, I'm not just an attorney, I'm also a gun guy. Is the prosecution here pointed out that prior to the actual shootings on the streets of Kenosha, in which Kyle Rittenhouse killed two men attacking him and grievously wounded a third man approaching him with a Glock pistol in hand, that Kyle Rittenhouse had fired that AR rifle precisely once before that night. Once. So this is not the case of Rittenhouse having lots of hours and thousands of rounds through that platform when he effectively defended himself on those Kenosha streets. He'd fired that AR platform once. And to me, that's a real testament to the ease of use and capabilities and suitability of the AR platform as a defensive weapon, really for anybody, for any law-abiding, mentally sound citizen who's looking for the ability to effectively defend themselves against deadly force attack. He'd fired that platform once and won those 3 fights on the streets of Kenosha, including an attack by a man feet away, armed himself with a Glock pistol. Pretty impressive performance by Kyle and by that platform. So if you don't have one yet, folks, I would encourage you, the laws within your jurisdiction permitting, of course, grab yourself an AR. They are pretty easy to use effectively in defense. So that's the state narrative. Kyle is essentially a vigilante taking the law into his own hands, but rather shockingly, the prosecutor's not putting forth much evidence in terms of what specifically he would need to overcome the obviously expected legal defense of self-defense, because being a vigilante is not a crime. And nobody even knows what that means. And of course, he's defining it here so loosely that it apparently includes calling 911. So it's really meaningless in this case. What the prosecution is going to have to do is overcome one of the 5 elements of self-defense. Really only 4, but innocence, imminence, proportionality, avoidance isn't really relevant here because he was in flight from his attackers when he defended himself, even if it applied under Wisconsin law. And then, of course, the reasonableness of his perceptions. So it'll be interesting to see to what extent the prosecution actually focuses on what's legally required to overcome that legal defense, as opposed to talking incessantly about how calling 911 and carrying a fire extinguisher to put out fires are the acts of a vigilante who's taking the law into their own hands. See how we're doing here for time. And of course, the defense narrative is going to be, as I've already kind of stated, that in fact, every single use of force here, including just pointing the gun around, which is the basis for the reckless endangerment charges, was justified as lawful self-defense. That Kyle was, in fact, the innocent victim of an imminent, unlawful, deadly force attack, and that his perception of that he was the victim of an imminent, unlawful, deadly force attack was a reasonable perception under the circumstances. That's what the prosecution has to overcome, one or more of those elements beyond a reasonable doubt. And of course, the defense narrative is going to be that the state has failed, not even come close to disproving any of those elements, and therefore overcoming. Now, that would certainly apply. The self-defense applies, obviously, to the intentional uses of force, the shooting of Rosenbaum, the shooting of Huber, the shooting of Grosskreutz. What about the recklessness charges? So basically here, the prosecution is arguing that, his muzzle crossed McGinnis, the journalist, and his muzzle crossed this unknown male. That was reckless conduct. Well, reckless conduct, folks, is unjustified creation of a risk and then intentionally ignoring the risk that was created. Unjustified. But conduct that meets the conditions of self-defense is not unjustified, it's justified. So it can't be reckless. It's not reckless. It fails to check one of the requirements for conduct to be reckless. Now, if you just walk down the street and nobody was bothering you and you started pointing a gun at people or waving a muzzle around, sure, that could readily qualify as reckless conduct because there was no justification for the conduct. But if the muzzle is moving around because you're defending yourself against imminent unlawful deadly force attack, that conduct is not reckless. That conduct is the opposite of reckless. And the fact that danger was created, let's presume for purposes of discussion, towards journalist McGinnis and towards the unknown male, that doesn't make it criminal conduct. Only if it was unjustified would it be criminally reckless. If it's justified, it's not criminal conduct, even though danger is created. Every time somebody uses a gun in self-defense, they're arguably creating danger to bystanders in the environment, whether that be police or private citizens. That doesn't make that criminal conduct if the display or use of the weapon qualifies as lawful self-defense. And so that's the recklessness charges. And of course, as I already noted with the gun charge, I just don't see any basis in fact or law for that gun charge. It would be a real pleasure to see Judge Schroeder, the trial judge in this case, throw that charge out before the trial even begins because it so blatantly lacks probable cause to support the charge. That almost never happens, unfortunately, but it certainly ought to happen on that gun charge in this particular case. Okay, folks, so that's just about all the substantive content I have. I do want to mention that we do have a sponsor for our coverage of the Arbery trial and the Rittenhouse trial. So CCW Safe has kindly agreed to sponsor our coverage. For those who don't know, when we cover these trials, it is a 15-hour-a-day effort on my part. I watch every single minute of the trial. I do real-time commentary as the trial is taking place, and then I do in-depth legal analysis in plain English of each day's events, always with at least an end-of-day post each day. If time allows, depending on how the court does things like lunch breaks, sometimes we'll have a midday analysis and an end-of-day analysis. But you get the plain English legal analysis expertise of myself on that case based on what actually happened in the courtroom, not some summary by an idiot journalist or something. My actual observation of the trial events, you get that every single day. And CCW Safe has kindly agreed to sponsor that effort on my part, at least for their members. So if you're a CCW Safe member, you will get that coverage on the CCW Safe website. You won't need to be a member of Law of Self-Defense. Of course, Law of Self-Defense members will also get the benefit of that coverage. It should go without saying. Whether our coverage of the trials is going to be more broadly available, open access, in other words, for people who are not CCW Safe members or not Law of Self-Defense members, is really a function of whether we get an additional sponsor. So somebody has to sponsor that effort on our behalf. We've done this kind of thing with various websites and forums before. I expect it's likely that one of them will step up, but at present we don't have a sponsor for that open coverage, in which case the content may well not be available except to CCW Safe and Law of Self-Defense members. Of course, the good news is that it's really inexpensive to be a Law of Self-Defense member. It's only about, well, a quarter a day under the worst of circumstances, but you can try out membership for 2 weeks for just 99 cents. If you don't like it within that time period, just let us know. We'll give you back 200% of your money, so it's a negative risk proposition. And if you decide to stay a member after that, again, it's only about a quarter a day, folks. It's less than $10 a month to be a member of Law of Self-Defense, and you get access to all our detailed coverage and legal analysis of these trials, as well as everything else that we do. And you can take advantage of that 2-week opportunity for 99 cents at lawofselfdefense.com/trial. One other thing I should mention before I turn to questions is it's quite possible these two trials will overlap. The Arbery trial is scheduled to begin October 18th, so in a couple of weeks. And the Rittenhouse trial is scheduled to begin Monday, November 1st, so a couple of weeks after that. I don't really expect the Arbery trial to be done by the time the Rittenhouse trial begins. 2 weeks would be pretty quick for such a politically charged case as the trial of the McMichaels and Roddy Bryan. And if they do overlap, obviously I'll be covering the Arbery case as soon as it begins. But if it's still in process when the Rittenhouse case starts up, I'll be shifting 100% of my resources to the Rittenhouse case. So my coverage of the Arbery case may end up being incomplete because I'm going to focus on the Rittenhouse case, which I think is more relevant to the law self-defense audience. So that will be my priority. And then we'll cover the Rittenhouse case, of course, all the way to the end. All right, folks, let me take a look here quickly through the comments. First, through the membership dashboard. Of course, we don't get too many questions from those folks because they're getting our content every time we publish, so they're pretty up to speed on everything. Let me take a look here at the Facebook comments. Joe Marsh asks, does self-defense insurance cover civil litigation? Certainly it does for CCW Safe. I believe most of the services that offer this kind of coverage have a civil component. I will caution, however, that the civil liability component is, to a large degree, an extent of your criminal exposure. And what I mean by that is the threshold for being convicted in a criminal court is proven guilty beyond a reasonable doubt. The threshold for civil liability is a mere preponderance of the evidence, 51% of the evidence, a much lower threshold. So if you're found guilty in criminal court, you're liable in civil court. I mean, it's baked in the cake because you were already found responsible at a much higher level threshold. One consequence of that is that if you're dealing with the criminal case and you're offered a plea, and sometimes the plea can be very favorable. And I know what you're all thinking. Hey, if it was lawful self-defense, I didn't do anything wrong, I would never take a plea. Folks, if you're looking at something like life plus 5 years in prison, if you're convicted at trial, and there's never a 0% chance of getting convicted at trial. The chance of getting convicted at trial is always greater than zero. I don't care how innocent you actually are. So if you're looking at some greater than zero risk of life plus 5 years, or you're offered a plea of, say, 3 years, maybe serve half of that, so still a felony conviction, but that's your maximum exposure, it would be pretty hard to say no to a deal like that. But if you do take that deal, and that may well be in your best interest to take that deal, to take a very favorable plea to a felony charge and a relatively modest prison sentence, modest compared to life plus 5, the moment you take that plea to the criminal charge, you're done for the civil exposure. Because by taking the plea, you're saying, I agree that I'm guilty beyond a reasonable doubt of whatever charge you're taking the plea to. Well, if you've been convicted beyond a reasonable doubt of that criminal charge, that's a much higher threshold than the civil threshold required for civil liability. And once you agree by taking the plea that your conduct was criminal, there is no civil coverage anymore from your insurance provider. First of all, if you look at their agreements, you become a member of these, every single one of them says, well, if you're found guilty, there's no civil coverage. And frankly, they wouldn't be permitted to offer civil coverage once you're found guilty because it would be against public policy. It would be insuring criminal conduct, admitted criminal conduct. And no insurance company in the United States is allowed to offer that kind of program. So the civil coverage is always contingent on you not being convicted and not taking a plea, which is just another way of being convicted. So be aware of that. Let's see. Okay, folks, I think that's everything, and we're pretty much right at the top of the hour. So thank you all for joining us here again. We are trying to make a little modest shift in how we do these shows. We've always called them the Law Self-Defense News and Q&A show. We're going to try to make them a little more topic-specific, as we did in this particular episode. I'm told that helps with things like social media, blah, blah, blah. I'm sorry, I'm just a small-town lawyer. I don't really know anything about the IT stuff, but people who do purport to know that stuff says this would be a better, more directed, more focused approach for various social media audiences, as well as, of course, for our membership. So with all that out of the way, folks, I will remind you all again that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.